My name is Amrit Bhargav, a lawyer based out of Chennai, and it is my privilege to take you through the Centenary Commemoration event in honor of the late Justice S. Natarajan, who served as a judge of the Supreme Court of India between 1986 and 1989. By way of signifying a beginning, may I request you all to rise for the Tamil Thai Vazhth.
நீராறும் கடலொடுத்த நிலமடந்து கெழிலொழுகும் சீராரும் வதனமென திகழ்வரத கண்டமிழே எக்கணமும் அதிசிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை முதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம் வியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
100 years have passed from 29th October 1924 to the days counting after the 26th day of October 2024. For us, it is 100 years of memories, experiences, and living continuities about a life that we have all come to commemorate, remember, and cherish. For this special occasion, may I request Mr. N. Ramesh Rajan to welcome the gathering.
Thank you, Amrit, and good evening to everyone. Respected Chief Guest of the evening, Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India, other guests of honor, Honorable Mr. Justice P. Sadasivam, former Chief Justice of India and former Governor of Kerala, Honorable Mr. Justice Ibrahim Kalifulla, former Judge, Supreme Court of India, Honorable Mr. Justice C. Nagappan, former Judge, Supreme Court of India and Chairman of the State Law Commission, Mr. P.S. Raman, Advocate General Tamil Nadu, and Dr. G. Viswanathan, Founder and Chancellor, VIT University. Retired Honorable Judges of the High Court, Honorable Retired Judges of the Supreme Court, and Honorable Retired Judges of the High Court, members of the legal fraternity, dignitaries, friends, and relatives. On behalf of my brothers, Mahesh and Suresh, and on my own behalf, it gives me great pleasure in welcoming all of you to the centenary commemoration function of my father, late Justice S. Natrajan. We are all indeed honored by your presence here this evening. Honorable Mrs. Justice Nagaratna, my father was a colleague of your father, Honorable Chief Justice E.S. Venkatramaya in the Supreme Court, and you had known my parents when they were in Delhi. I had the good fortune of getting acquainted with your father and your family when I was living in Bengaluru. Your father was a noble soul and a perfect gentleman. I used to enjoy my interactions with him and became very close to him. On one occasion when I met him, there was tension between our two states, and he told me that, Ramesh, if the government permits, your father and I can quickly solve the issue. I could take the liberty of approaching him for advice or guidance as I would have with my father, and in turn, your father was always ready to guide and assist me. I greatly benefited from his guidance and assistance in the early part of my career. I still cherish the memories of my interactions with your father and the affection he showed me. It was therefore only natural that when we first decided to have this function, we thought of your name as the first choice to come, and I'm really happy that you readily accepted my invitation. And to deliver the commemorative lecture, which I am sure everyone is looking forward to. Your Lordship, it is a matter of great pride that you are following in the footsteps of your illustrious father, by becoming a judge of the Karnataka High Court, judge of the Supreme Court of India, and you will eventually be the Chief Justice of India with the unique distinction of being the first woman to occupy the highest judicial position in the country. Several of your recent judgments have demonstrated and made people aware that you are a bold judge who will not hesitate to uphold a good and just cause. Honorable Justice Sadasivam, you have the distinction of being the first and only Chief Justice from our state, Tamil Nadu. I understand that when you were in your term as Chief Justice, you were responsible for several initiatives and reforms, including service conditions of judges, which greatly benefited the judiciary and the judges. After your retirement as the Chief Justice of India, you had a very meaningful and successful tenure as the Governor of Kerala. You were acquainted with my father from the time you were in the office of Shri K. Doraisamy, Senior Advocate, whose family is like an extended family for us. Sir, I thank you for readily accepting my invitation to participate and release the Commemoration Souvenir. Honorable Mr. Justice Krishnakumar, I am very thankful to you for kindly accepting my invitation to participate in this function and offer your felicitation. Sir, I am aware you have had to reschedule your travel plans in order to be here with us this evening and give your address, and I am very grateful to you for the same. Honorable Mr. Justice Kalifulla, you have had a long and successful career as a lawyer, Judge of the Madras High Court, Chief Justice of the Jammu and Kashmir High Court, and as Judge of the Supreme Court. Our families have had a long association spanning 3 generations, and our families both hail from Salem district. You have always been very warm and cordial whenever I had the occasion to meet you, sir. I am indeed thankful to you for kindly agreeing to be with us this evening and offer your felicitations on the occasion. Honorable Mr. Justice Nagappan, you too have had a long and successful service, starting as a district judge, judge of the Madras High Court, Chief Justice of the Odisha High Court, and later as the judge of the Supreme Court of India, and you are now currently occupying the post of chairman of the State Law Commission. Again, our families have had a long association, and your mother and my mother were schoolmates and childhood friends. They remain close friends and regularly kept in touch till the end. I am thankful to you, sir, for having accepted my invitation to participate and speak on the occasion. Mr. P.S. Raman, Advocate General, my father and your father were good friends and had mutual high regard for each other. And I am thankful to you, sir, for having accepted my invitation and sparing your time to participate and speak on the occasion. Dr. G. Viswanathan, it is indeed a matter of great pride that you have founded and established several world-class institutions, educational institutions, including VIT University, which is currently ranked as among the top 10 engineering colleges in the world. My father and you had known each other for more than 5 decades. And my father had presided over the first convocation of VIT University, which was then called the Vellore Engineering College. Sir, I don't know if you recall, it was you who first approached me more than a year ago, asking me inquiring as to what I'm going to do for my father's centenary. And from then, you have been giving me guidance in this regard and advising me how to go about. Again, thank you very much, sir, for being here this evening with us and speak and offer your felicitations. My father was born on 29th October 1924, and his birth anniversary fell on 29th October 2024. But considering that the Deepavali was on 31st October, which was followed by a long weekend, we decided to hold the function today. My father was born in Salem and completed his schooling in Salem. He did his degree from Loyola College, Chennai, and went on to complete his law degree from Madras Law College. He was appointed as public prosecutor in 1959, district and sessions judge in 1965, chief presidency magistrate in 1970, and he was elevated as judge of the Madras High Court in 1973. After serving for over 13 years as judge of the Madras High Court, he was appointed as judge of the Supreme Court in 1986, where he served for about 3.5 years before retiring in October 1989. Apart from his judicial career, my father was deeply involved in many social and cultural and charitable institutions and activities, including being president of the Cosmopolitan Club, the Indian Officers Association, Indian Society of Criminology, Indian Council of Social Welfare, Guild of Service, etc. He was also the chairman of the committee for the formation of the East Coast Road, set up by the central government of India, and chairman of the committee for establishing the Periyar University, set up by the government of Tamil Nadu. I would like to just touch upon two qualities of my father. First was his compassion and empathy for others. There would always be a steady stream of visitors to our house when we were growing up, seeking my father's help or assistance with some school or college admission, employment, or transfer. I once told my father that between the time he spent on his judicial work, the time on social and other engagements, and the time he spent with visitors, there was very little time that we got to spend with him as family. He explained to me that it was only when someone was in hardship or difficulty that they approach others for help, and it would not only be improper but also cruel for him to turn them away in such a situation. Every person who came to him for help or assistance, irrespective of their position or status, caste, creed, or community seeking help, was received with the same courtesy, given the same patient hearing, and the same sincere efforts were made to help them. He told me that more often than not, just a patient hearing would generally comfort them with the relief that someone had just listened to their problems or hardship. He also told me that on his part, he would make every effort to help them, and beyond that, it would be God's grace and their luck if they got the relief or not. It was almost as if my father felt that God had placed him in a position to help others, and that it was his duty to do so. I cannot even recall a single instance where my father was harsh or turned away someone who approached him for help. It is probably for this reason that even 35 years after his retirement and 10 years of his passing, I still come across people who narrate to me how their lives had been touched and benefited by my father's goodness and help. And also, there is the very same reason that our family continues to have the goodwill and affection of so many of people. The second quality was his generosity of spirit and hospitality. Ours used to be an open house, and apart from the numerous visitors, we invariably had relatives and guests staying and visiting and staying in our home. No guest could leave without having some refreshment or food. In this regard, my father had a very able and supportive partner in my mother. My parents were gracious hosts and always made visitors and guests feel at home when they came to visit us. Some of my father's colleagues in the Supreme Court have told me that it was only after your father moved to Delhi that the judges of the Supreme Court started meeting socially. My parents were happily married for 61 years and were an ideal couple. As a couple, they were much sought after to preside over marriages and other auspicious functions and give their blessings. When I used to accompany them to temples, other devotees would come up to them and seek their blessings. In the last few years of his life, my father had penned down some of his thoughts and experiences, which he titled Family History and Rambling Reminiscences, which he meant mainly for the benefit of his family and close relatives to know about our ancestors and some history. At the end of the book, he wrote, and I quote, "I am in the evening years of my life, and I do not know when time with me will be no more. I am, however, thankful to God Almighty for having blessed me in so many ways and enabling me to render help to many people in many ways. My fervent prayer to the Almighty God is that till the last moment of my life, I should be active and be able to live up to the advice given by John Wesley. Do all the good you can, by all the means you can, in all the ways you can, in all the places you can, at all the times you can, to all the people you can, as long as you ever can." I can proudly say that my father lived by these words till his last breath. My brothers and I are blessed to be born to our parents. I again welcome each and every one of you with folded hands, and thank you for honoring us by your presence this evening in memory of my father. Thank you very much.
Thank you, sir, for vivifying the evening with such a plethora of memories. Centenaries are not only about remembrances, they are, as we observe today, a commemorative occasion that charges our minds with the flavors and fervors of a personality whose gifts and graces were rare to find. In celebrating that life, we begin with honoring our valued dignitaries on the dais who have kindly accepted and graced the evening. May I now request Dr. Umayal Ramesh Rajan to honor the Honorable Justice B.V. Nagaratna, Judge Supreme Court of India, with a memento and a shawl signifying this evening. Now request Mr. N. Suresh Rajan to present a memento and shawl to all of our other dignitaries, starting with the Honorable Mr. Justice P. Sadasivam, former Chief Justice of India and former Governor of Kerala. To felicitate the Honorable Mr. Justice D. Krishnakumar, Judge the High Court of Madras, with a memento and shawl in commemoration of the Centenary event. Now, to felicitate the Honorable Mr. Justice F.M. Ibrahim Kalifulla, former Judge the Supreme Court of India, with a memento and shawl conveying the symbolism of this evening. I request Mr. N. Suresh Rajan to honor the Honorable Mr. Justice C. Nagappan, former Judge the Supreme Court of India and Chairperson the Tamil Nadu State Law Commission, with a souvenir and shawl as a token of our gratitude. Present Mr. P.S. Raman, Senior Advocate and Advocate General of Tamil Nadu, with a memento and shawl as a mark of felicitation. I invite Mr. N. Suresh Rajan to felicitate Dr. G. Viswanathan, Founder Chancellor, VIT Deemed University, with a memento and shawl as a mark of commemoration. Thank you, sirs. For us, Justice Natrajan has ever remained in our hearts and minds. His invisible presence is always with his family and friends. But his centenary commemoration is significant for stirring emotions of reverential nostalgia that have resulted in the preparation of a centenary souvenir that is just about to be released. We now have the launch of the souvenir. May I request Justice P. Sadasivam, former Chief Justice of India and former Governor of Kerala, to kindly unwrap the book and present the first copy to Justice B.V. Nagaratna, Judge of the Supreme Court of India. Now may I request Justice P. Sadasivam to kindly present copies of the souvenir to all our dignitaries on the dais so that we can have a photo with the souvenir. Now may I request all of you to hold up copies for our own photo moment. The souvenir is a two-in-one filled with tributes from eminent personalities who have recalled their times with Justice Natrajan, and the second part, which is the annotated version of the autobiography already written by Justice Natrajan, edited by the well-known chronicler of Old Madras, Mr. V. Sriram. It was an honor and pleasure to have such an erudite editor and raconteur to be part of this milestone initiative, and we are truly enriched by his contributions. This evening is special for a variety of reasons, first being the presence of such distinguished guests on the dais and such a distinguished audience who have made this evening truly memorable. For us here at Chennai, that is Madras, we are fortunate to receive with delight Her Lordship Justice Bengaluru Venkatramaya Nagaratna, Honorable Judge, the Supreme Court of India. It is my duty to say a few lines in honor of her ladyship, Justice B.V. Nagaratna, who completed schooling in Bangalore and New Delhi. Finishing university education at New Delhi, was enrolled in 1987 and practiced in a variety of matters before the Karnataka High Court. Elevated as a judge of the Karnataka High Court in 2008, Justice Nagaratna was directly elevated to the Honorable Supreme Court of India on the 26th of August 2021. Known for the intellectualism that distills judicial reasoning from factual matrices, Justice Nagaratna is renowned for the hallmark of incorporating independent and thought-provoking reasoning in her ladyship's judgments, especially the well-known dissents that have evoked interest in legal circles. Her ladyship's characteristic interventions during the hearings in the hard-fought 9-judges bench judgment on mineral rights showed us the making of a scholarly judge and reminded the bar that the preparation and sound grounding in legal principles are necessary for constitutional adjudication. an accomplished daughter of an illustrious father, India is ever grateful to the late Justice E.S. Venkatramaiah, former Chief Justice of India, who was an apostle of judicial statesmanship and learning. We're extremely happy to receive Justice B.V. Nagaratna in her ladyship's maiden visit for a speaking engagement here in Chennai, and we are sure that it will be the first of many. May I humbly invite her ladyship to deliver the Justice S. Natarajan Centenary Commemoration Lecture 2024 on the subject Checks and Balances, a View from the Looking Glass.
Vanakkam and namaskar to everybody. Honorable Justice P. Sadasivam, former Chief Justice of India, Honorable Justice D. Krishnakumar, Judge High Court of Madras, and other brother and sister judges of the Madras High Court, Honorable Sri Justice F.M. Ibrahim, Kalifulla, and Honorable Sri Justice Nagappan, former judges, Supreme Court of India, Sri P.S. Raman, Advocate General, Government of Tamil Nadu, Dr. G. Viswanathan, Founder and Chancellor, VIT University, Sri N. Rajan, S. Mahesh Rajan, and Sri N. Suresh Rajan, the illustrious sons of Justice S. Natarajan and Srimati Bhagirathi, and their families, friends, associates, learned senior advocates, and members of the bar, distinguished invitees. I see a lot of students, dear students, members of the media, ladies and gentlemen. Once again, a good evening to everybody. I deem it a privilege to be in Madras. You see, we as advocates, we always valued the judgments which came from the Madras High Court. And I particularly learnt a lot of civil law from the benches which delivered the judgments in the Madras High Court. I therefore deem it a privilege to be in Chennai. We always say Madras, though it is now called Chennai. We all, I suppose, we are still old-timers. And I'm happy to be here today. And I think it's a privilege for me to be invited to deliver the Justice Shivashankar Natarajan Centenary Commemoration Lecture and to make my humble contribution to the path of legal thought that Justice Natarajan's memory signifies. I must extend my gratitude to Sri Ramesh Rajan and his family and his brothers and their families for inviting me to deliver this lecture and for the kind words that have been spoken about me. Born on 29th October 1924, Justice Natarajan witnessed and contributed to the development of independent India's constitutional legal system. He was a contemporary of my father, who was born on 18 December 1924. So next month he would also complete his centenary. And they shared many benches together, including, I may say, as it is of recent and current discussion, 2 7-judge benches in India Cements Limited and Synthetics and Chemicals. Justice Natarajan was a part of that bench. My father presided as the Chief Justice, and Justice Sabyasachi Mukherjee wrote both those judgments. And the coincidence is that I, in a 8:1 dissenting judgment, I have upheld both those judgments in India Cements and Synthetics and Chemicals. Of course, mine is a minority view, but it is a happy coincidence to remember that today. Having received his early education in Salem, he joined Loyola College, Madras, and then the Madras Law College for his education in the law, charting his journey as a member of the bar before the Madras High Court in August 1947, when we got our independence. Justice Natarajan's versatility and deep grasp of law was in civil, criminal, industrial, and labor matters. He was appointed as the public prosecutor in Salem in 1959, and thereafterwards he was appointed as the district and sessions judge in 1965. His judicial service was characterized by a pragmatic and intellectual understanding of the law. He was later elevated to the bench of the Madras High Court in 1973 and thereafter to the Supreme Court in 1986, and he retired in October 1989, a time which he admirably used in rendering judgments of significant import for the times to follow. He was also a part of the Thakkar Natrajan Commission, which inquired into a controversy. I think it is called the Fairfax controversy. His wife, Srimati Bhagirathi, was a source of great strength to Justice Natarajan. Even after retirement, the couple were very active socially, and as Mr. Ramesh Rajan said, they were very sought after, especially for being benign with their blessings to youngsters. The true measure of a judge's character and personality is through his or her judgments, providing for development of law. I deem it fit to mention a few judgments of Justice Natarajan that reflects his incisive commitment to the pursuit of development of law and its employ as a tool for social justice. He demonstrated his legal acumen and deep wisdom in his judgments and contributions to the salient 14 constitution benches he was a member of. In A.R. Antule versus R.S. Nayak, he was a part of the leading majority opinion authored by Justice Mukherjee, which, by a 5:2, set aside an earlier Constitution bench judgment. Incidentally, the reference to the 7-judge bench was made by my father, sitting with Justice Mukherjee, on the correctness of the order of the Constitution bench. I may mention as of interest that Justice Venkatachalaya and Justice Ranganathan wrote the dissenting judgments there. His commitment to law as a tool for justice and respect for the Constitution shown in his judgment in Begum Subanu, wherein the country's dailies hailed it as a trend-setting judgment. Justice Natarajan held that the right of a Muslim husband to a polygamous marriage cannot act as a bar on operation of Section 125 of the CRPC. In a perfect confluence of judicial activism and restraint, Justice Natarajan was aware of the court's limitations through the centrality of the doctrine of separation of powers. This mindfulness of the delicate but functional balance that needs to be maintained between different organs of the government is most visible in his opinion in State of J&K versus Mahmood Ahmed. In that case, the High Court had said that Sections 8 and 14 of the Evacuee Administration of Property Act 1950 had outlived their purpose after 39 years of the Act coming into force, and directed officers of the state not to entertain any application made in future by persons laying claim to properties which had been notified as evacuee property. Justice Natarajan, espousing his respect for the constitutional separation of powers, effectively observed that the High Court was incorrect in nullifying a statutory provision by determining its utility, that being a matter of decision for the legislature. It is this judgment which has made me speak about the topic of today, namely principle of checks and balances under our Constitution. The fundamental principle of checks and balances under the Constitution rests on the fulcrum that the exercise of power by any one authority, namely the legislature, executive, or judiciary, must be balanced and checked by the exercise of power by other authorities. Closely related to the principle of checks and balances is the functional principle of separation of powers. Its origin can be traced to the Locke's second treatise on civil government, or Montesquieu's The Spirit of the Law. The French philosopher Montesquieu emphasized the mutual exclusiveness of the three organs of the government, namely the legislature, the executive, and the judiciary. The purpose underlined in the separation doctrine is to diffuse governmental authorities so as to prevent absolutism and guard against tyrannical and arbitrary powers of the state. For it is Lord Acton who said that power corrupts and absolute power corrupts absolutely. This is also to protect the freedom of the people. In the famous case Keshavananda Bharati, the Supreme Court observed that separation of powers between the legislature, executive, and judiciary is part of the basic structure of the Constitution, which cannot be destroyed by any form of amendment. The concept of separation of powers creates a system of checks and balances, by reason of which the powers so distributed to each of the organs do not predominate or disable the other organs from exercising and discharging the powers and functions entrusted to them. In practice, the theory is accepted with the hope of coordination and cooperation between the three organs of the state to achieve the aim of upholding constitutional values, or if I may say, constitutional dharma, and the laws for the protection of people's individual and collective rights. Justice P. Sadasivam, who is here with us today in Bhim Singh, said, "The Constitution does not prohibit overlap of functions, but in fact provides for some overlap as a parliamentary democracy. But what it prohibits is such exercise of power of the other branch, which results in wresting away of the regime of constitutional accountability." These instructive words encapsulate the pertinency and position of the doctrine of separation of powers in our Constitution, and therefore the reason for my choosing this topic, checks and balances under the Indian Constitution through a looking glass. The basic structure of our Constitution aids as a looking glass and takes us to a clearer picture of testing any exercise of powers. In that spirit, I would speak on the origins of the doctrine of separation of powers and its place under the Indian Constitution, and I would also speak upon parliamentary supervision of executive action. Next, I would speak on judicial review, which is a matter of checks and balances under the Constitution to check legislative and administrative excesses, and I would put forth the centrality of judicial independence to rule of law. Before discussing on the topic as such, let me ignite this audience with the recent judgment of the Supreme Court for a clearer concept of what I would like to say in furtherance of the topic. In re directions in the matter of demolition of structures, writ petition civil number 295/2022, it just came 3-4 days ago, it's not yet reported in the reports. The judgment written by Justice B.R. Gavai along with Justice Viswanathan said, and I quote, "If a citizen's house is demolished merely because he is an accused, or even for that matter a convict, that too without following the due process as prescribed by law, in our considered view, it will be totally unconstitutional for more than one reason. Firstly, the executive cannot declare a person guilty, as this process is the fundamental aspect of judicial review. Only on the basis of accusations, if the executive demolishes the properties or property of such an accused person without following the due process of law, it would strike at the basic principles of rule of law and is not permissible under the Constitution. The executive cannot become a judge and decide that a person accused is guilty and therefore punish him even before the court could convict him by demolishing his residential or commercial properties. Such an act of the executive would be transgressing its limits." The Supreme Court went on to say, "The chilling sight of a bulldozer demolishing a building when authorities have failed to follow the basic principles of natural justice and have acted without adhering to the principles of due process reminds one of a lawless state of affairs where might was right. In our Constitution, which rests on the foundation of the rule of law, such high-handed and arbitrary actions have no place. Such excesses at the hands of the executive will have to be dealt with the heavy hand of the law. Our constitutional ethos and values would not permit any such abuse of power, and such misadventures cannot be tolerated by the court of law, unquote. This is one stark example of executive excesses in recent years. Further, and in the era of tribalization or tribunalization, however you want to pronounce it, the constant refrain is that the executive trenches into areas of adjudication and therefore accused of usurping judicial functions by appointing persons with executive bias. The reason is they say that the high courts have so much of docket load, so much of pendency. Therefore, let us create tribunals to unload the pressure on the High Court. Initially, it started with the Service Tribunal, Central Administrative Tribunal, State Administrative Tribunals, and that experiment has failed in certain states, and the matters, I am told, have gone back to the High Court. But then it went on from one tribunal to another tribunal to another tribunal. No doubt, in some cases, the tribunals may be a good opportunity for retired judges to have a rehabilitation. But at the same time, who are the members, technical or otherwise, who are assisting such judges is the question. In Roger Matthew, the Constitution Bench of the Supreme Court issued a writ of mandamus to the Ministry of Law and Justice, central government, to carry out a judicial impact assessment of all the tribunals. The central government responded with the notification of tribunal, appellate tribunal, and other authorities' qualification, experience, and other conditions of service of members' rules 2020. This was again challenged by the Madras Bar Association on the ground that the rules were violative of the principles of separation of powers and independence of judiciary. The Supreme Court has directed that the Union shall constitute a National Tribunals Commission, which shall act as an independent body to supervise appointments and functioning of tribunals, to consider disciplinary proceedings, and to take care of administrative and infrastructural needs of tribunals. This is in order to maintain independence in judicial adjudication. The call of the modern technocratic, transparent, and efficient governance structures beckons a constitutional regime of checks and balances that travels beyond traditional state actors. Rather, the structure of 21st century open governance frameworks makes it prudent to acknowledge that the regime of checks and balances also responds to citizen participation. Professor Jerome G. Kerwin, a professor of political science at the University of Chicago, in 1945 said, the inextricable link between structure and governance in the following words, and I quote, "Forms of government, it is true, do not reform the men who administer them, but they do make it easier for good administrators to do the job well, and they do very often make it easier for the people to observe the operation of the government," unquote. Thus, an efficient rendition of principle of checks and balances allows and emboldens responsible legislators to effectuate their scheme for the nation, while still enabling harmonious coordination with other power holders and also ensuring open governance. In this regard, I must say that the relationship between the President vis-à-vis the Parliament under Article 74 and governors in relation to state legislature and Article 163 and the executive respectively have been the center of controversy in a series of cases before the Supreme Court. Although not entirely ceremonial in everyday exercise of executive power, the President and the governors have been given a certain degree of discretion also. Justice A.N. Ray, speaking for the Supreme Court in Samsher Singh, explained that whenever the Constitution requires the exercise of any power or function, the satisfaction of the president or the governor is not their personal satisfaction or anybody else's satisfaction vicariously arrived at, I may say. It is the satisfaction in the constitutional sense, particularly when the aid and advice of the Council of Ministers is not contemplated. This is when there is purely discretionary exercise of power by the president and the governors of the states. Such is the friction between political incentives and constitutional methods that in a contrary landscape, checks and balances are necessary even on the lawmaking power of presidents and governors, acting on the aid and advice of the Council of Ministers. Equivalent to a parliamentary legislation, the Constitution authorizes the executive to exercise original legislative power. The President may promulgate ordinances under Article 123, and it is easy to remember the governors on 213, 123 and 213, that is how we studied as a student. Provided that at least one house of the Parliament or the legislature must not be in session, and that the President must be satisfied that circumstances exist which render it necessary for her to take immediate action. Practically promulgated by the President on satisfaction of the ministers, ordinances are products of legislative power vested in the executive and beyond the ordinary grounds of judicial review. Nevertheless, ordinances must be laid before both houses once the Parliament reconvenes. Finding a convenient path to lawmaking sans legislative approval, several governments have abused the possibility of re-promulgating ordinances. In the famous case of D.C. Wadhwa, the Supreme Court frowned on ordinances being kept alive for periods ranging from 3 to 14 years, merely by re-promulgation, and converted an exception into a norm. The Supreme Court denigrated it as Ordinance Raj. This usurpation of legislative power by the executive was held contrary to India's constitutional scheme. Ultimately, recently, a 7-judge bench in Krishnakumar also affirmed the view that was taken in D.C. Wadhwa and held that re-promulgation of ordinances is a fraud on the Constitution and a subversion of democratic legislative processes. On that note, I will now turn to judicial review of parliamentary and executive action. On September 17, 1787, George Washington, the then President of the Constitutional Convention, put in 2 sentences as the essence of the judicial task. He said, and I quote, "Individuals entering into society must give up a share of liberty to preserve the rest. It is at all times difficult to draw with precision the line between those rights which must be surrendered and those which may be reserved." Unquote. Drawing the line is, in my view, the core task of the judicial organ under the Constitution. Of all the unanticipated political developments since 1787, none has been more consequential than the acceptance of judicial review by the Supreme Court of United States in Marbury versus Madison. I need not go into the details of that case, but at that time, James Madison in 1788 on the separation of powers in Federalist Papers number 47, the quoting of that merits some interest. Quote, "The accumulation of all powers, legislative, executive, and judiciary in the hands or the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." Unquote. Since then, this principle has been exported all over the world, including into India, where the Constitution, since its inception, in Articles 32 and 226, read with Article 13, have recognized the principle of judicial review. The principle has since been hallowed and cemented by reiteration by our constitutional courts. The critique that judicial review is illegitimately grafted into our popular government is wholly misplaced and in fact improper. For one, this idea suggests that democracy is meant only to reflect one popular opinion. That is not so. One single popular opinion is not the only opinion in a democracy. With all humility, I think it is reductive. The process of democracy, in my view, is meant also to refine and elevate public opinion from all angles and viewpoints. There cannot be only one public opinion applicable to all. Ultimately, democracy is also about arriving at a consensus by taking the best from a variety of ideas and opinions that emerge at a particular point of time. Therefore, in a true democracy, there cannot be scuttling of divergent opinion or thought, nor a curb on ideas which may appear contrarian. Secondly, and more importantly, democracy is dedicated to preconditions of liberty and equality. Without the judicial protection of individual rights against their encroachment, the preconditions of liberty and equality would fall. To be sure, my submission is not that majorities will necessarily fail those conditions, but the truth is that they often do. While majorities have a right to work their mistaken wills anyway, that right is not untrammeled. It is the judiciary and the judiciary alone that determines the limits of that right. In fact, the legitimacy of the courts comes precisely from the fact that courts act without reference to popular sentiment, and by doing so, they address injustices which majoritarian institutions are fundamentally incapable of addressing. In a succinct sentence in Marbury versus Madison, Chief Justice Marshall of the Supreme Court of the United States espoused the role of judicial review. He said, and I quote, "It is empathetically the province and duty of the judicial department to say what the law is," unquote. Under our transformative constitution, the power of judicial review has time and again been invoked to prevent and remedy injustice. Such an injustice could be a result of state neglect or action, or be a social malaise. To borrow the fallacious expression from Vivian Bose J., it has been a zealous endeavor of the Indian judiciary that the Constitution should work for the butcher, the baker, and the candlestick maker. The judges of the highest adjudicatory body in the world's largest democracy consider it their duty to redeem their constitutional oath and do justice no less to the pavement dweller than to the guest of the five-star hotel. These are the words of Justice Chinnappa Reddy in Randhir Singh. Therefore, it will not be excessive or out of place to say that the judiciary is at the epicenter of constitutional government. Our constitutional endeavor has been to ensure that judicial review acts as a measured but effective check on exercise of power by Parliament and the executive. Beyond the challenge to the vires of any act of Parliament or a state legislature as being violative of Part 3 of the Constitution, the judiciary is the bulwark against abuse of power by the executive, whether at the center or at the states and lower levels. Therefore, statutory provisions limiting the jurisdiction of courts and provisions seeking to exclude the jurisdiction of courts are strictly construed or struck down. One example of that is in Quixote Holohon, where a challenge was raised to paragraph 6.1 of the 10th schedule of the Constitution, which seeks to impart finality to the decision of the Speaker or the chairperson as to whether a member of a House has become subject to disqualification because of defection. The Supreme Court held that such finality could not detract from or abrogate judicial review of the decision under Article 136, 226, and 227 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malafites, non-compliance with rules of natural justice, and perversity are concerned. More concerned with day-to-day governance, judicial control of delegated legislation deals with the concept of excessive delegation, substantive and procedural ultra-vires, and such other grounds of review. Additionally, judicial control is exercised over administrative discretion by way of judicial review when administrative duties are not undertaken in accordance with the recognized principles of administrative law. I need not go in detail about those to this enlightened audience, except referring to promissory estoppel, legitimate expectation, proportionality, restitution, and such other principles which are applied to strike down erroneous exercise of administrative discretion, which are of great importance in administrative law. Further, the checks exercised by the judiciary are not restricted to examining the compatibility of the content of laws with Part 3 rights, but also extends to judicial overview of actions within the legislative body and the manner in which such actions are conducted. Anil Kumar Jha is an example where the Supreme Court issued directions on the manner in which a trust vote in the Jharkhand Assembly should be conducted. To illustrate, judicial decisions have worked as checks and balances on prospective and sitting members of the legislature. In Association for Democratic Reforms, the Supreme Court held that the derivable from Article 19(1)(a) for voters is a right to know who they were electing. Therefore, the court directed disclosure to every voter of detailed information relating to a candidate. This carving of Article 19(1)(a) has contributed to new rights under Article 19(1)(a). In fact, the theoretical basis has been acknowledged since long. In state of Uttar Pradesh versus Rajnarayan, the respondent sought access to documents in an election petition, rejecting the state's claim of privilege from disclosure. The Supreme Court traced the right to know from the freedom of speech as it built on the ideal of transparency of governance. This approach, I find, acts as a dual check and balancing mechanism. The citizen parliament loop must be discussed in the context of Indira Nehru Gandhi versus Rajnarayan, wherein the parliament used its amending powers to amplify a moral and legal wrong, and furthermore to validate an invalidating election by withdrawing the jurisdiction of the judiciary. The court finally held that such an amendment declaring the judgment void without removing the basis for judicial decision, making it without any judicial application to the facts of the case, would toll the death knell of the democratic structure of the Constitution. Justice H.R. Khanna opined that if the 39th Amendment was allowed to stand, the mechanism for determining the real representatives of the people in an election as contemplated by the Constitution would be destroyed, and a judgment inter se parties pending appeal would be declared void without any judicial application of mind. Thereby, the separation of powers doctrine would be truly discarded. This brings me to the next theme, that is legislative overruling of judicial pronouncements. I would only touch upon it briefly for paucity of time, as I am conscious that there are other learned speakers to follow me. The legislative power to amend the enacted law with retrospective effect is not only subject to our legislative competence, but is also subject to several judicially recognized limitations, which I would not like to highlight for paucity of time. By ensuring that the legislature cannot simpliciter overrule judicial decisions, the principle of separation of powers is maintained. In NHPC, recently I had an opportunity to deal with the interlink between judicial review, separation of powers, and its inextricable relationship with rule of law. Such instances would amount to an attempt to legislatively overrule a court's judgment by a legislative fiat and would therefore be illegal and colorable exercise. The power of judicial review is a part of the basic feature of our Constitution, which is premised on the rule of law. Simply setting aside a decision at naught would not be sufficient. I would not like to go in detail with regard to Sita Soren, and where the P.V. Narasimha Rao decision was overruled recently by the Supreme Court, which dealt with whether MPs and MLAs have constitutional immunity under Articles 194(2), that is for the state legislature, and Article 105(2), that is for the parliament, involving allegations of bribery. This judgment marks a significant precedent, emphasizing that lawmakers are subject to anti-corruption laws and that legislative privilege cannot shield criminal or corrupt behavior. Recently, in state of Punjab, the Supreme Court said and explained that the governor is a symbolic and cannot withhold action on bills indefinitely. In an exposition of checks and balances between different constitutional post holders, the court explained that reconvening a sitting of the Legislative Assembly, which has not been prorogued, is an exclusive prerogative of the Speaker and not the Governor. This instance surfaces the presence and strength of checks and balances. There are more details about the said judgment, which I would not like to go about it. Then I would come to the question of judicial independence, a check to balance judicial powers. Necessary to the enforcement of checks and balances by judicial control is judicial independence. The inception point of any understanding of independence of the judicial organ is the doctrine of separation of powers and the consequent independence of the judiciary from the executive and the legislature. It is not only independence of the judiciary as an institution, but independence of the individual member of the judiciary. Where independence exists, courts are able to be more forceful mechanisms for defense of constitutionalism and justice. Article 50 of the Constitution urges for separation of judiciary from the executive in public services and the law. The focus of independence of judiciary is what Montesquieu conceptualized, that there should be institutional separation and judicial independence. Ultimately, it depends on every member of the judiciary. Political insularity is one aspect, the other is with regard to impartiality. The third component is the position of courts within the larger political system and their functional relationship with the other branches of the system. Independence of judiciary is more closely related to supremacy of the law. Judicial independence and supremacy of the law work together to guarantee that rule of law is not to be eroded by political pressures in existence at any particular point of time. Insulating judges from political influence advances the same object. Both these concepts are therefore important underpinnings to the rule of law. The next aspect is whether independence of the judiciary is related to the concept of judicial accountability. My answer is yes. The two values are to be perceived as complementary rather than antithetical. Judicial independence is merely the other side of the coin from judicial accountability. The two are not at war with each other, but rather are complements. Neither is an end in itself, but rather means to an end, or a variety of ends surrounding the constitutional ideals. The further aspects on judicial independence I would not like to touch upon, except quoting Justice Frankfurter in Baker versus Carr when he said, quote, "The court's authority, possessed of neither the purse nor the sword, ultimately rests on sustained public confidence in its moral sanction." I am always concerned about the public confidence in courts. The rule of law, which is defended by an independent judiciary, plays a crucial function by ensuring that civil and political rights and civil liberties are safe and equality and dignity of citizens are not at risk. Ultimately, the extent of the judiciary and its independence relates to independence, impartiality, integrity of the men and women holding judicial office. It is therefore all important to appoint meritorious judges who have the pulse of the Indian society and the country in their hearts and the rule of law in their mind while seeking to render justice. It is the personality of judges that will determine, in truest sense, the extent of judicial independence and autonomy. Justice Natarajan, he personified what I just said. In my view, independent exercise of judicial power is not only a judge's prerogative, but also a duty. It is therefore important that judges decide on their own appreciation of the law and as per their conscience, unfettered by the views of others. It is ultimately the individual conviction of a judge, his or her courage and independence, which would decide matters before the law. From therein would be true justice. This is recently we find that the Supreme Court has once again come up with quite a few dissents. And I'm happy to say that both my learned sister, Justice Bela Trivedi, and I have dissented in the Constitution bench matters. Therefore, not that women are more independent as such, but I want to bring it as a happy coincidence from the aspect of independence of judiciary, because the expression of independence from another judge is also an aspect of independence. This is independence of judiciary in its most enlightened form, I would say. On that note, I conclude my lecture with a firm hope that all gathered here will reaffirm our commitment to securing independence of the judiciary, remain alive to the challenges to it, and be vigilant in safeguarding and strengthening the judiciary. With this lecture, I pay my humble tribute to Justice S. Natarajan, and I thank the family of Justice Natarajan for inviting me to this lecture. As usual, my judgments are very long, and if I'm given a microphone also, I'm long. I'm sorry if I've tested your patience. I thank each one of you for your kind attention. Namaskar. Thank you, sir. I hope I did not overstep.
Thank you, Your Ladyship, for that masterly lecture on the constitutional parameters of the trinity of the executive, legislature, and the judiciary. Your Ladyship struck the contemporary chord: political incentive versus constitutional guarantees. Traversing a labyrinth of case law and principle, the lecture was an absolute masterclass in scholastic erudition. We are elated to note that Justice Natarajan is still remembered by those who knew or shared in his friendship. In that galaxy of guests, we have with us Justice P. Sadasivam, former Chief Justice of India and former Governor of Kerala. It is my pleasant duty to respectfully request him to say a few words.
Honorable Mrs. Justice P.V. Nagaratna, Judge, Supreme Court of India, Justice F.M. Ibrahim Kalifulla, Justice Nagappan, former judges of the Supreme Court of India, Justice D. Krishnakumar, senior most Judge, High Court of Madras, Mr. P.S. Raman, Learned Advocate General, Government of Tamil Nadu, Dr. G. Viswanathan, Founder and Chancellor, VIT University, Mr. N. Ramesh Rajan, Mr. Mahesh Rajan, Mr. Suresh Rajan, other distinguished invitees, particularly honorable judges, former judges, members of the bar, my friends in media, good evening to all. At the outset, I convey my happiness to participate in the birth centenary celebration of most respected judge, late Justice S. Natarajan, and I have already released the book about his journey in this function in the presence of judicial dignitaries. Hailing from Salem district, which is adjoining to my native district, that is Erode, Honorable Justice Natarajan had many admirable qualities. Some of the key qualities which personifies him during lifetime are, I cannot mention all. Number one, dress code. He was always impeccably dressed, befitting the occasion. whether it was an official function or social gathering. Number 2, time management, punctuality. Not only did he practice this consistently, but also insisted that the younger members of the family must follow. Number 3, maintaining the dignity and decorum of the office. He was meticulous in his approach to the public office, be it judiciary, Natarajan College, trust chairmanship, custodian of Madras Race Club, or president or patron of Shekilar Kalaham. Number 4, Justice Natarajan was a natural leader. Calmness, empathy, good listening skills, and a sharp mind were the hallmarks of his leadership. As a young lawyer, I had many opportunities, and I appeared before him and argued many matters. I need not repeat his qualifications and various posts held by him, starting from public prosecutor Salem in 1959, ending with highly respected judge of the Supreme Court of India in 1986-1989. He also served as a head of various bodies, organizations, which have undoubtedly benefited from his vast experience. After his retirement in 1989, he refused to accept any post-retirement offers or postings and chose to contribute to society and lead a peaceful retirement life rooted to culture and tradition. He served as a chairman of Natarajan College for Women for many years, working for its development and excellence. In his outstanding work for that organization, he was practically perpetuating the legacy of late Mr. B.L. Natarajan, a leading criminal lawyer of his times in Madras, who bequeathed his properties for establishing the Natarajan College. Since I released the book, that is a centennial tribute, I want to say a few words. That comprises 2 parts. That is part 1, tributes and messages received about Justice Natarajan. Part 2, Justice Natarajan had written a book in 2011 titled Family History and Rambling Reminiscence, Close Reminiscence, which was more for the benefit of his family members, close relatives and friends, for them to understand the family history and the ancestors, as well as sharing some of the thoughts on his childhood, marriage, career standing with the public prosecutor in 1959 to Supreme Court judge from 86 till October 1989. His sons had requested noted historian and author Mr. V. Sriram to review, edit and annotate the book to make it more relevant for the larger public audience and society. The second part comprises 12 chapters, beginning with ancestry and ending with chapter which deals with Justice Natarajan's involvement in and commitment to social causes and activities. Now, I am not going to furnish all the other details. And coming to my lecture, and I want to say 1 or 2 things about me, though in the introduction the speaker has mentioned, because most of the persons present here or sitting judges or former judges or members of the bar or law students. No, as far as I am concerned, only to give a message to the audience. I come from a rural village. I studied only in government school and government college. Only by work and I can say by hard work, I reached this position as 40th Chief Justice of India from the rural village. And I am not mentioning other details. Only thing, on 13/7/2019, Dr. Ambedkar Law University is teaching laws to all the people of Tamil Nadu, conferred a doctorate degree of Doctor of Laws LLD, and the same was awarded by the Honorable then President of India in the presence of then Governor of Tamil Nadu. Again on 25/1/2021, after completing my 5 years office as Governor of Kerala, after 2 years I received a communication from the Rashtrapati Bhavan. The President of India sent a letter appreciating my service as a best governor and a baton decorated with the emblem of Indian Republic as a memento through District Collector Erode, and the same is adorning in my residence. I am not going to elaborate further. Our only because already I am not going to take more time. I am going to highlight some certain important constitutional issues with reference to the judgments rendered by Honorable Justice Natarajan. Our constitution has been hailed as one of the best in the world. The incisive and in-depth knowledge about India's social system had helped Baba Saheb Dr. Ambedkar in drafting many provisions that ensure equality and freedom of the people and remain unquestionable till date. While democracy confers the right on the elected government through its legislature to amend the rules, even the Constitution, our judiciary has rightly stepped in to point out the limits of such rights to uphold the sanctity of our Constitution. Democracy entitles a citizen to many unquestionable rights as individuals. At the same time, man-made disasters have challenged people's right to live in healthy environments. One instance, I'm pointing out only one or two instances. One instance was the Bhopal gas leak tragedy, which took away hundreds of lives. Until then, there was less transparency about the work of factories and less hope of adequate compensation in the event of disasters. But the judiciary's pronouncement that an enterprise handling an inherently dangerous or hazardous activity was strictly and completely obligated to repay everyone influenced by an accident caused by it, enforced a trend of absolute liability without any exemption. The effect of such verdict of Supreme Court has written the industrial environment by adding a greater sense of concern and social responsibility to it. The framing of the precautionary principles in which responsibility to anticipate, prevent, and attack the causes of environmental degradation was spelled out in the Vellore Citizens Forum case also deserves mention. Though we have a set of fundamental rights, certain things like health, water were not regarded as part of them. It was up to the Supreme Court in Narmada Bacho Andolan versus Union of India and others to uphold water was the basic need for the survival of human beings and is part of the right to life and human rights as enshrined in the Article 21 of the Constitution. As one who was fortunate to lead the Indian judiciary, I am also here, I am confining to one or two judgments. For some time, I have the satisfaction of having part of some of the decisions that could bring in social change in the country. Example, Reliance Gas judgment. I had observed that the national assets belong to the people and should be explored through public sector undertakings, thus helping to change the people's outlook towards natural resources. Another important case is 1993 Mumbai blast case, sentencing several accused persons, including Bollywood actor Sanjay Dutt to 5 years of imprisonment. This was the biggest case ever heard in the history of Supreme Court. Here, nothing wrong in mentioning, at that time, the Chief Justice of India was Justice Kapadia from Bombay, very strict judge. One day, during lunchtime, his PA came to my chamber. He said, "My lord, CJI wants to see you at 4:30. Please today come at 4:30 to your chamber." I was little worried. Why CJI is asking me any mistake I committed? Then I went there. He offered a cup of tea. Then he said, "Brother, in Bombay, this Bombay bomb blast, that was the first blast in India, took place. The trial took place nearly 14 years. Further appeal lies only to Supreme Court. High Court has no role. So we have received records and other things. I decided to entrust the case to you. Please accept. And I am giving you a choice to select a companion judge. That is very rare occasion." Then I conveyed my thanks. "I will try my best, my lord." I selected Justice P.S. Chauhan. Then I returned. After 1 week, I asked my secretary, some vacation, I think March, holy vacation, I asked my secretary to circulate the judgment copy of the Bombay blast. She was standing like a tree. I asked her, "What is the difficulty?" "Sir, I have to procure a truck, lorry to send the judgment to your home." Because trial went on 14 years, thousands of pages. You can't carry it in a flight. You have to carry it in a lorry. Then I said, "Drop it. I will try my best here itself." Then afterwards, we fixed that case. We mentioned no adjournment, no Passover. We heard that case 10 months, every day at 10:30 to 4 o'clock, no break, nothing, no other case. And within 4 months, I delivered a judgment, 1,600 pages. The Allahabad AER, in the wrapper, the judgment was separated, printed in a separate book. In the wrapper is the biggest judgment, biggest case ever heard by the Supreme Court, and sent to my house with a request to keep it in your house as a memory. I am still keeping that judgment. And another is Safai Karamchari Andolan versus Union of India, to the union and state government and union territories to prohibit manual scavenging and to grant 10 lakh as compensation to the families of those who die in sewers since 1993. Scavenging has been one of the ills against which noble souls like Mahatma Gandhi and Dr. Ambedkar had spoken and acted. To imagine the practice being in village in this century was a national shame. That the nation needed a judicial pronouncement to stop it points to the judiciary's concern for the downtrodden in the context of inability of the political system to enforce such rules. The system of ensuring reservation for the disabled in government jobs also got boost. That is, after my judgment, the government increased the reservation for disabled. We mentioned, hereafter we have to mention specially abled. The parliament increased 3% to 4% through based on our judgment in Union of India versus National Federation of Blind. Another is a Rajiv Gandhi assassination accused case, delay in disposal of mercy petition, which resulted in converting death into life, and life because they served more than the required period. Now all of them have gone. Here also, nothing wrong in mentioning only one sentence. After retirement, normally on the date of retirement, the President of India for the Chief Justice, retiring Chief Justice, offers a dinner at Rashtrapati Bhavan. After 1 week, I received a phone call from the Rashtrapati, Mr. Pranab Mukherjee, asking me and my wife to come for a lunch. I went there because at that time I retired. After finishing lunch, he asked his daughter to take my wife to Mughal Garden. He holded my hand and took me to his office chamber, his personal chamber, and showed, Judge, I am keeping that judgment rendered in delay in disposal of mercy petition, Karunai Manu. He said, I am keeping your judgment on my right side. Whenever I receive mercy petition, the judgment will point out I should not delay it. Immediately I pass an order. Now I said, that is not the reason, sir. If a reason is acceptable, then delay can be condoned. In that case, the occurrence took place in within 60 kilometers from Madras. There are several flights from Chennai to Delhi, several trains, several truckloads. They could have brought the records immediately. They took 7 to 8 years for disposal of mercy petition. That will affect, as per the constitution, even death convicts get right. That's why we changed the sentence. Why I am mentioning some judgments of it give not only useful or benefit to the public, it may give a good direction to the government. The electoral process has finally, I may not take another 5 minutes, not more than 5 minutes. The electoral process has a decisive role in any society, and its transparent and foolproof conduct points to the credibility of a democracy. As a co-author of the judgment that led to the introduction of electoral reforms nota, when you go near when you go for voting, one very public interest litigation came from Jammu Kashmir, mentioning that according to me, all candidates are not suitable. How can I put my vote? It's a very important question. We summoned, and I was the Chief Justice, we summoned the Chief Election Commissioner to the court with these missions. We spent the whole day in the first court. Then ultimately we only, on suggestion, fixed this nota at the end. If the nota number goes, it may give some message to the political parties to select a good candidate. Then BBVPT paper trial. Some asked, sir, when I put a vote, how can I know that I put a correct vote or correct person? Then we directed the Election Commission to bring that paper trial. That is also, finally I am mentioning this MP-led constituency fund for MPs and MLAs. Originally, they came up before the then Chief Justice K.G. Balakrishnan. I was his junior judge. Then I conveyed humbly to the Honorable CJI, my lord, this is going to be a confrontation between judiciary and elected members. Why not, subject to your approval, why not be referred to Constitution bench? He readily agreed. Then within a week, he constituted a Constitution bench, and I was a fourth member in that. We heard it for one full day, judgment reserved. At the end, in the chamber of Chief Justice, then Chief Justice, I explain to all the judges because I can proudly say I come from a rural area. I know the problems of farmers and workers and villagers, and I know how our opposition MPs and MLAs are being treated. They cannot get good schemes. With this fund, they can do something for the constituency. Then all the other 4 judges asked me to prepare a judgment. Within a week, I prepared a 77-page judgment. All 4 upheld, agreed and signed. It's a unanimous judgment wherein I mentioned if elected government, elected by the people, elected government does something for the benefit of the public and it comes within their jurisdiction as per our constitution, nobody can stop it, neither government nor a governor or a president. So that's why after delivery of this judgment, I mentioned this in a it's a constitution bench judgment. Next day, many political leaders came to my residence. No, I said, why? Sir, first time the Supreme Court has recognized the elected government must be given more importance than the nominated persons. Then I said, if you are within your norms and powers as per the constitution, nobody can interfere. Take it from me. I spent some time with them, and all of them have left. Finally, some of the judicial interventions have been criticized as judicial overreach, judicial activism, etc. However, such criticism has not diminished the judiciary's concern for and responsibility towards the people. After all, it was the judiciary that encouraged the concept of public interest litigation in consonance with the principles enshrined in Article 39, capital A of the Constitution of India to protect and deliver prompt social justice. The effect of public interest litigation on our society is enough to prove the positive role played by the judiciary in strengthening our democracy. With this, I conclude my address. I wish to congratulate Mr. Raman and other family members for remembering Justice S. Natarajan and celebrating this centenary year. Thank you.
Thank you, sir, for those kind words about Justice Natrajan, his sterling contributions and signal achievements. We are grateful for Justice Sadasivam's presence and the observations about the book that was just released. The Madras bench and bar were literally a second home for Justice Natrajan, who originally hailed from Salem. His connection with colleagues and those far younger to him was special and memorable. Representing that accord of honor and long-standing relationship, it is my pleasant duty to request Justice D. Krishnakumar, Judge, High Court of Madras, to speak on the occasion.
Honorable Mrs. Justice B.V. Nagaratna, Judge, Supreme Court of India. Honorable Mr. Justice P. Sadasivam, former Chief Justice of India and former Governor of Kerala. Honorable Justice F.M. Ibrahim Kalifulla, former Judge, Supreme Court of India. Honorable Justice C. Nagappan, former Judge, Supreme Court of India. Esteemed brother judges who are present here, and also the former judges of the High Court. Mr. P.S. Raman, Learned Advocate General of Tamil Nadu. Dr. G. Viswanathan, founder and chancellor of VIT University. Members of the legal fraternity, senior advocates and junior advocates. Ladies and gentlemen, distinguished guests and family members of the Honorable Justice S. Natarajan and students who are all present in this occasion. Good evening to all. I extend my warm and heartfelt greetings on this momentous occasion. Today we gather to pay tribute to an extraordinary individual whose remarkable journey has left an indelible mark on our legal landscape. My senior K. Doraisamy, senior advocate, is closely associated with the family of Justice Natarajan. I am very thankful to the family members and organizer for inviting me to this memorable event. We are privileged to have Mr. Justice B.V. Nagaratna, Judge, Supreme Court of India, as chief guest for this evening function, sharing our Lordship's invaluable insights on the topic of checks and balances under the Indian Constitution. Her Lordship's illuminative lecture has thrown light and paved way for a profound understanding of constitutional laws and a commitment to preserve the rule of law. It has left us with renewed appreciation for the mechanism that upholds justice in our society. We are truly grateful for Her Lordship's thought-provoking lecture, and this speech will be most useful for young lawyers and students who are all sitting here, offering them a deeper grasp of constitutional principles essential to their careers. We are honored to have Justice P. Sadasivam, former Chief Justice of India and Governor of Kerala, who released this Souvenir and shared his thoughts. Your Lordship, remarkable tenure as 40th Chief Justice of India has left a lasting impact on your judiciary. We are also honored to have with us Honorable Justice Kalifulla, former Judge of Supreme Court of India, Honorable Justice Nagappan, former Judge of Supreme Court of India. Known for their integrity, they have set high standards of judicial reasoning and reinforcing trust in the judiciary. Their legacy serves as an enduring inspiration for fair-minded jurisprudence. Let us take a moment to appreciate the significance of this occasion. Justice S. Natarajan's remarkable career, spanning over 4 decades, serves as a testament to his unwavering commitment to justice, fairness, and integrity. From his earlier day as an advocate to his appointment as Supreme Court Judge, his is shining example of dedication, perseverance, excellence, and we are reminded that true greatness transcends time and mortality. His enduring legacy has spanned 100 years, which serves an inspiration to us all. Notable, Justice Natarajan's enrollment as an advocate in 1947 coincided with Indian independence. Those were tumultuous times marked by uncertainty and change. Yet he navigated this challenge, circumspect with courage and conviction, laying the foundation for a remarkable career. Honorable Justice Nataraj started his advocate career in Salem district. Throughout his illustrious journey, Justice Natarajan demonstrated unwavering commitment to the principles of justice, fairness, and integrity. As we celebrate Justice Natarajan's centenary, we remember his notable appointments: a public prosecutor in 1959, getting his appointment as a district judge and district and sessions judge in 1965, elevation to Madras High Court as a judge in 1973, and ultimately reaching the pinnacle of Indian judicial system as Judge of Honorable Supreme Court of India in 1986. Beyond his impressive judicial career, Justice Natarajan's leadership extended to various roles. He is also holding the Board of Trustees at Natarajan College, fostering education and growth, which already the earlier speakers has mentioning about. Honorable Justice Natarajan hails from a Zamindar family. In those days, getting an opportunity to argue in court as his junior advocate was very challenging. Justice S. Natarajan was known for encouraging and allowing young lawyers to argue case in his Lordship's court, showcasing his commitment to nurturing future legal talent. Most notably, the Honorable Supreme Court appointed him as President of the Indian Olympic Association, a testament to his exceptional character and ability. Justice Natarajan's contribution to Indian law are immeasurable. He was a stalwart of the legal community, known for his sharp intellect, analytical mind, unwavering commitment to justice and fairness, exceptional leadership, and administrative skills. As we celebrate his centenary, we honor not only Justice Natarajan's remarkable achievement, but also the values he embodied: integrity, compassion, and commitment to justice. His legacy serves as a beacon, guiding us through the complexity of our profession. Before I conclude, I once again express my deepest gratitude to Justice Natarajan's family for their unwavering support throughout his remarkable journey, and I thank the family members of Justice Natarajan, Mr. N. Ramesh Rajan, Mr. N. Magesh Rajan, and Mr. N. Suresh Rajan, the organizer, and volunteers who have worked diligently to make this event a grand success. As we reflect on Justice Natarajan's life and legacy, let us draw inspiration from his remarkable journey. May his commitment to justice, fairness, and integrity continue to guide us all. Thank you very much for giving this opportunity. Thank you.
Thank you, my lord, for the centennial tribute and thoughtful address that made us realize the salience of a life bygone. We also have here with us Justice F.M. Ibrahim Kalifulla, a judge who radiated happiness and shared a keen sense of justice. As recalled earlier, the families of Justice Natrajan and Justice F.M. Ibrahim Kalifulla have known each other for over 3 generations, and this is an occasion to renew and reinforce that relationship. May I now humbly invite Justice Ibrahim Kalifulla to address the gathering.
Respected Sister Mrs. Justice B.V. Nagaratna, Honorable Justice P. Sadasivam, Honorable Justice Krishnakumar, Brother Justice Nagappan, the Advocate General Mr. P.S. Raman, my good old friend Dr. Viswanathan, the sons of the illustrious Judge Justice Natarajan, Mr. N. Ramesh Rajan, Mr. N. Magesh Rajan, Mr. Suresh Rajan, other family members of Justice Natarajan, my brother judges, present and former of my parent High Court, ladies and gentlemen, press and media. Good evening to all of you. எனது இந்த உரையை வள்ளுவன் வாக்கிலிருந்து துவக்க ஆசைப்படுகின்றேன். வள்ளுவன் அவர் சொல்லாத விஷயமே கிடையாது. அதுவும் அந்த குறள் ஒவ்வொன்றும் ஒவ்வொரு வார்த்தையும் ஒவ்வொரு சொல்லும் அவ்வளவு அர்த்தம் பொதிந்ததாக இருக்கும். நான் இன்றைக்கு இந்த பேச்சுக்காக திருக்குறளை எடுத்து பார்த்த பொழுது குறள் 67 எனக்கு கண்ணில் பட்டது. தந்தை மகற்கு ஆற்றும் நன்றி அவையத்து முந்தி இருப்பச் செயல். ஒரு தந்தை தன் மகனுக்கு ஆற்றக்கூடிய நன்றி அவையத்து முந்தி இருப்பச் செயல் என்று சொல்லுகிறார் வள்ளுவன். தந்தை தன் மகனுக்கு ஆற்ற வேண்டிய கடமை அவனை சான்றோர்களின் சபையில் முன்னவையாக இருக்கச் செய்வதே ஆகுங்கிறான். அதுக்கு அர்த்தம் இன்றைக்கி இந்த சான்றோர்கள் சபையை பாருங்கள், மேலேயும் சரி கீழேயும் சரி எந்த பக்கம் பார்த்தாலும் சான்றோர்களின் மொத்த சபை. இந்த சபையிலே இந்த பிள்ளைகளுக்கு அவர்களுக்கு இந்த ஒரு பெருமையை சேர்த்து தந்த அந்த மனிதன் நீதி அரசர் நடராஜன் அவர்களுக்கு நாம் என்றென்றும் நம்முடைய வாழ்த்துக்களை தெரிவிக்க கடைப்பட்டிருக்கிறோம். அதே வேளையிலே வள்ளுவன் இன்னொன்றையும் சொல்லுகிறான். குறள் 70 மகன் தந்தை காற்றும் உதவி இவன் தந்தை எண்ணோற்றான் கொள் என்று சொல். பாருங்க, தந்தைக்கு அந்த கடமை, பிள்ளைகளுக்கு அந்த கடமையை சொல்லுகிறான். மகன் தந்தைக்கு ஆற்ற வேண்டிய உதவி என்னவென்றால் இவனை பெறுவதற்கு இவன் தந்தை என்ன தவம் செய்தானோ என்று அனைவரும் சொல்லும்படி செய்வதே ஆகும். இன்றைக்கி அந்த பிள்ளைங்க அந்த குரலையும் பூர்த்தி செஞ்சுட்டாங்க. இதை விட தன் தந்தைக்கு இந்த பிள்ளைகள் வேறு என்ன செய்ய வேணும்? இவ்வளவு சிறப்பாக அவர்கள் தந்தைக்கு அவர்களது ஜஸ்டிஸ் நடராஜனுடைய மனைவியார் துணைவியார் திருமதி பகீரதி அம்மாள் அவர்களுக்கு இந்த நூற்றாண்டு விழாவை எடுத்து நம்மையெல்லாம் வரவழைத்து இப்படி ஒரு சிறப்பான ஒரு விழாவை அவர்கள் எடுத்ததற்கு அந்த தந்தைக்கும் பெரும் சிறப்பு, அந்த பிள்ளைகளுக்கும் பெரும் சிறப்பு. வாழ்வாங்கு வாழ வேண்டும் என்னால் நாம் வாழ்த்துவோம். இது வந்து கமெமரேஷன். திஸ் இஸ் அ கமெமரேஷன். Commemoration is to remember about that great personality. See, everybody has found the glory, have placed before you the glory of the great stalwart of the judiciary, Justice Natarajan. As my brother Justice Krishnakumar and the comparer said, for 3 generations we are associated with that family. My grandfather, my maternal grandfather, Khan Bahadur Kalifulla Sahab, he was a Diwan of Pudukota, and the Tamil Vale through P.T. Rajan, both of them were very good friends. And when through P.T. Rajan was the Chief Minister of Madras Presidency, my grandfather was his member of his ministry as a finance minister. That is how the relationship started. Thereafter, when Honorable Justice Natrajan joined the judicial fraternity, my father, late Mr. Justice M. Fakir Muhammad, he also joined the judiciary, and both of them happened to sit in the Madras High Court and shared the bench between 1981 and 1983. That is how the next generation, now that in the third generation, the 3 Rajan brothers have met me, and they are able to recognize the earlier contacts of our family. I would only like to say that Justice Natarajan, everybody knows that, in fact, I have appeared before him as a lawyer. In fact, in our office we conducted a case, a famous case, a Jeevan Lal case. It was relating to the payment of gratuity. Justice Natarajan, because he had appeared for in labor matters when he was practicing lawyer, he held that the payment of gratuity should be calculated in a particular way under the Payment of Gratuity Act, and that judgment was upheld. That was a case which was argued in our office, and that judgment, of course, it went against us, but the principle laid down by Justice Natarajan was upheld by the Supreme Court, and it rules the field even as on date. There are any number of judgment of His Lordship Justice Natarajan we can quote. Not necessary, because Justice Nagaratna has made a very wonderful lecture. I was only requesting Mr. Magesh Rajan that let that lecture be, a copy of it be given to Dr. Viswanathan, who is having a law school, and through him that lecture can be circulated to all the law schools, so that every student of law will be greatly benefited by your lecture, sister. And in the present day context, the checks and balances which you have culled out and you have narrated is wonderful, and it's a research work. So we get the benefit of that lecture, and I have requested Mr. Magesh Rajan to request you to give a copy of it, so that we will get circulate it to all the law schools. Justice Natarajan, I will conclude it by just saying that he was a thorough gentleman, very able lawyer. He was a lawyer of not only the private parties but also for the state. He was a celebrated judge of the Madras High Court. He rendered landmark judgments in the Supreme Court. A well-respected leader of many cultural, charitable and educational institutions. He was a very good father, a very good husband, and as I said, quoting Valluvan, how both of them, the father and the sons, have excelled in their career. Therefore, in this commemoration occasion, we will all wish the family of Justice Natarajan all good things, and we will cherish his memories and follow his footsteps. And I also at this occasion thank the family members of Justice Natarajan for having given me this opportunity. Thank you very much. Thank all of you.
Thank you, sir, for highlighting the significance of this centenary event in Tamil that we cherished, and for recalling anecdotes that were inimitably yours. With a career that has spanned the district judiciary to the Supreme Court, our guest in Justice C. Nagappan, former judge the Supreme Court of India and chairperson the Tamil Nadu State Law Commission, is also a long-time friend of Justice Natarajan and his family, who has shared in the memories of a great life. May I request Justice Nagappan to address us.
I'll be very brief. Honorable Mrs. Justice B.V. Nagaratna, Judge Supreme Court of India, Honorable Justice P. Sadasivam, former Chief Justice of India, Honorable Justice D. Krishnakumar, Judge Madras High Court, Honorable Justice F.M. Ibrahim Kalifulla, former Judge Supreme Court, Mr. P.S. Raman, Advocate General of Tamil Nadu, Dr. Viswanathan, founder and chancellor of VIT University, Mr. Raman and his brothers, family members of Justice Natarajan, Honorable Judges of the High Court, Honorable former judges, senior advocates, members of the bar, distinguished guests, ladies and gentlemen. We have gathered here to honor and celebrate the remarkable life and legacy of Justice Natarajan with reverence and admiration. He was not only an eminent judge of the Supreme Court, but also a man whose principles and character have inspired countless individuals, of which I am one. Born in an era marked by social upheaval, Justice Natarajan grew up instilled with a sense of duty towards justice and equality. He pursued law with a fervor that not only defined his illustrious career as a lawyer, but also prepared him for the role he would later fulfill as a distinguished judge. He seamlessly transitioned from being a student of law in pre-independent India to being among those who enrolled on 4/8/1947, just before we became a free country. As a lawyer, he was known for his integrity and dedication, and his knowledge of law was complemented by a deep understanding of human values and the socio-economic fabric of our nation. Having joined as a direct recruit district judge, he was later elevated as a judge of the High Court and thereafter as a judge of the Supreme Court. As a judge, Justice Natarajan was known for his fairness and compassion. He was unwavering in his commitment to justice, after often going beyond the text of the law to understand the human elements involved in every case. Renowned for his mastery of the English language. Justice Natarajan's eloquence and flowery prose have left an indelible mark on the legal fraternity and beyond. More than that, not just words, his language was a conduit in compassion and empathy, reflecting his deep-rooted intention to help all who sought his wisdom and guidance. His judgments were marked not only by their legal acumen, but also by their humanity. He believed, as Swami Vivekananda articulated, that justice is the foundation of all the virtues. Justice Natarajan's contributions to the judiciary were instrumental in shaping a more just society and ensuring that the voices of the marginalized were heard and valued. A beacon of inspiration to countless young lawyers and judges, Justice Natarajan's exemplary conduct and stellar reputation have set a high standard for legal professionals to aspire to. His ability to seamlessly bridge gaps, interact with individuals from all walks of life, and manage diverse institutions showcased his versatility and leadership acumen. Beyond the courtroom, he was a devoted family man. While I think of Justice Natarajan, inseparable from him is his wife, Mrs. Bhagirathi, daughter of Sir P.T. Rajan. The couple together are known for their hospitality from Salem not just to Chennai, but even in the national capital, Delhi. No visitor has ever gone unfed, satisfied, and happy. They also fed the minds with good conversation and heart with warm thoughts. Justice Natarajan embodied the values of love, respect, and responsibility towards his loved ones, reinforcing the idea that true success begins at home. His family shares a legacy of warmth, compassion, and support, traits that he nurtured in them, reflecting his belief in building strong familial bonds. In the words of Thiruvalluvar, Anbum Aranum Udaithayin Ilvalkai Panbum Payanum Adu. If a householder leads a life of love and virtue, that life alone will be fruitful and cultured. Justice Natarajan lived by this philosophy, creating a home where kindness and empathy were paramount. We can see that in his children today, and that will be a moment of great pride and joy for the man. My earlier speakers, all of them have repeated. This is also, I'm also repeating it for the reason, very rarely we find such kind of family, such kind of legacy. Justice Natarajan extended his compassion beyond family, continuously engaging in philanthropic endeavors. He was a good Samaritan, caring for those in need and uplifting the downtrodden. He contributed to numerous educational initiatives and projects designed to foster a better tomorrow for our society. As a philanthropist, his belief in education as a cornerstone for progress was evident through his support for institutions that aim to provide quality education to aspiring young minds. He saw education not just as a privilege, but as a right for every child, a belief that aligned with Swami Vivekananda's assertion that education is the manifestation of the perfection already in man. He instilled a deep respect for learning, inspiring future generations to aspire to their highest potential. The greatness of a person is measured by how much he contributes to the world. Justice Natarajan exemplified this wisdom in every facet of his life. Justice Natarajan embodied the qualities of a model citizen. His commitment to the community and the nation was unwavering. He engaged actively in discussions about social justice and reform, demonstrating that a judicious approach to life goes hand in hand with civic responsibility. His strong moral compass guided him in contributing to the betterment of society, reinforcing the ideals of honesty and integrity in both public and private spheres. Gentle in manners and unfailingly courteous, he was grace
personified. Justice Natarajan's journey from the hallowed halls of the Supreme Court of India to the hearts of those he touched is nothing short of extraordinary. As Ramesh Rajan put it, very, very close, both my family and Justice Natarajan's family are so close for the reason that my mother and Mrs. Bhagirathi Natarajan were classmates at Madurai. It is just like my home only. I used to frequently visit them. பலமுறை நான் பார்த்திருக்கிறேன். பல்வேறு தரப்பட்ட மக்கள் அவரிடம் தினம் வருவார்கள். ஒவ்வொருவருக்கும் ஒவ்வொரு கோரிக்கைகள் இருக்கும். கோரிக்கைகள் வந்து மோஸ்ட்லி ஸ்கூல் காலேஜ் அட்மிஷன், இட மாறுதல், இல்லை ஜாப் இன்டர்வியூ, இல்லை திருமணத்தை நடத்தி கொடுக்கணும், இல்லை குடும்பத்தில் பிரச்சனைகள் இருக்குது அந்த பிரச்சனையை தீர்த்து கொடுக்கணும். அதாவது ஒரு பெரிய மனிதரிடம் போனால் நமக்கு தீர்வு கிடைக்குங்கிற ஒரு நம்பிக்கையோடு அவ்வளோ பேர் வருவாங்க. எனக்கு மிகவும் ஆச்சரியமாக கூட இருக்கும். நான் அந்த மாதிரி ஜாஸ்தி பார்த்ததில்லை. இப்படி ஒரு பர்சனாலிட்டி ஒருத்தரை பார்க்குறது ரொம்ப ரேர், வெரி ரேர். அவ்வளவு பேர்ட்டையும் புன்முறுவலோடு அவங்க சொல்கிறத கேட்டு தன்னால் என்ன முடியுமோ அதை உடனே செய்வார். அவங்க திரும்பி போகிறப்ப திருப்தியோடு தருவாங்க. அதனால தான் சொல்கிறேன், அவரை யாரும் மறக்கவும் முடியாது. எல்லார் வீட்லேயும் அவரை பற்றி இன்றும் நினைவுகள் ஓடிக்கொண்டு தான் இருக்கும். அப்படிப்பட்ட உயர்ந்த உள்ளம், உயர்ந்த பண்புகள் கொண்டவர் ஜஸ்டிஸ் நடராஜன். As we celebrate Justice Natarajan today, let us remember the profound impact he made as a judge, a philanthropist, and a family man. People only saw a friend in him and were buoyed by the tall figure he was, both literally and in stature. His legacy will endure in the lives he touched, the judicial principles he upheld, and the love he spread. In the words of Swami Vivekananda, I quote, "Be the change you wish to see in the world," unquote. Justice Natarajan was indeed that change, a beacon of hope who strived relentlessly for justice, equality, and humanity. May we all strive to embrace the lessons from his remarkable life. I thank the family for having given me this opportunity to commemorate the life of Justice Natarajan. Thank you.
Natarajan noticed and fostered relationships with lawyers that bloomed into generational association and bonhomie. In cultivating these, there was goodwill and good-intentioned wishes that drew him closer to many people. One of them was the family of the late Mr. V.P. Raman, and we have with us Mr. P.S. Raman, Senior Advocate and Advocate General of Tamil Nadu, to commemorate the occasion. May I request him to say a few words.
I think the operative word is few. Dignitaries on and off the dais, Vanakkam and good evening. before it becomes good night, I'd like to keep it really short. That's the advantage of being one of the last speakers or late speakers, because much of the things that needed to be said have been said beautifully by people speaking before you. Today, in fact, it was a lovely thing which the organizers have done, because many of you who are used to public meetings would always know that the order of priority of speaking is actually the reverse. Justice Nagaratna should have been the last to speak, but she was the first. I believe so. So that makes the task easier for those of us who are following. I was given 10 minutes, and I like to be meticulous in my preparation, and I had prepared a speech for 9 minutes and 50 seconds. I will make it half of that. I was pleasantly surprised when Ramesh and Rajshekhar met me and asked me to come and speak this evening. I readily accepted. It was only later, when I began preparing this address, that I came to realize that this privilege of addressing you all today has been conferred on me not because of my current position as the Advocate General of the state. That is only transitory glory. I believe it is because I carry with me the reminiscences of late Justice Natarajan through the eyes and ears of my revered father, late V.P. Raman, unquestionably one of Justice Natarajan's closest friends. Their association started in the 50s itself, courtesy close family connections which my grandfather A.V. Raman had with both Sir P.T. Rajan as well as Bhaktavatsalam, both former chief ministers of the state who are all directly connected with Justice Natarajan's family. So highly did my father value the association of Natarajan that he even timed my enrollment. On 5th of September 1984, I enrolled in the forenoon, and the first case I argued was that afternoon before Justice Natarajan at Kotal number 12. I vividly remember strenuously going through every sentence in the paper book and the pleadings, little realizing much later that in a writ of mandamus for refund of duties, more often than not, notice is issued at admission without much arguments. Not surprisingly, Justice Natarajan would not let that be. And much to the amusement of those present in court that day, some of you are here, Justice Natarajan started quizzing me intensely on several aspects, and only after being satisfied that his friend's son had truly come prepared for the matter did he smile with his trademark tip and said, "Admit, notice issued." It is worth recounting here in this audience. Justice Nagaratna spoke of docket explosion. It is ironical that that matter of the duty went up and down 3 times, and after I became designated as senior counsel, 30 years later, it got resolved. Justice Natarajan's direct elevation to the Supreme Court without having to go through the route of becoming a Chief Justice of the High Court was unusual in those days, but there were no raised eyebrows because the legal community knew the merit behind this appointment. Even his colleagues whom he quote-unquote superseded did not envy him this preferment. While his tenure in the Apex Court was just 3 years, in almost the 3 decades of serving as a judicial officer in all levels, Justice Natarajan had left behind a great legacy for others to emulate. In fact, before getting into the talk on separation of powers, Justice Nagaratna has beautifully outlined several of Justice Natarajan's lovely judgments in the Supreme Court, and that's another thing I'm straight away skipping. I'm coming to a more personal side of the man. Just a few months back, another side of Justice Natarajan as a friend came to light when one of his closest friends from his Salem days, Maxim Lobo's wife, Bertha Auntie, passed away. I think many of Justice Natarajan's friends will remember Maxim and Bertha. They go back to Salem. when Bertha auntie passed away, her daughter brought to my attention that just a few years before his passing, Justice Natarajan had actually handwritten his departed friend's widow's last will and testament. This is just a reflection of how deep his sense of friendship and affection to all around. No wonder that in the few minutes that I was looking at the souvenir, I found that Justice M.N. Mangatashalaya, former Chief Justice of India, has written, and this is what he has written in the souvenir which you will all get. Upon his retirement in 1989, I deeply missed the presence of a bon vivant, a joie de vivre, and above all, a dear colleague, unquote. Justice Natarajan had a very subtle sense of humor and a great felicity for the spoken and the written words. One of the things that immediately pop up to my mind in his very erudite judgment in the famous Arak shop supply case batch, which came before his elevation to the Supreme Court in 1986. He began the judgment with the statement that the Arak bottlers and dealers in Tamil Nadu had incurred the wrath of Bacchus. When he did not know that Justice Natarajan was referring to the Roman name for Dionysus, the Greek god of wine, such amusing references also exhibited his vast literary knowledge. It is my failing that I had not read Justice Natarajan's autobiography titled Family History and Rambling Reminiscences, something he penned and had privately published sometime before he ascended to the throne of grace on 11th of April 2014. Extending beyond his involvement with law, Justice Natarajan was also very closely associated with the Ithiraj College at Chennai, arguably one of the top women's arts colleges, which owes its name and founding to the immortal V.L. Ithiraj, the legendary criminal lawyer who was an inspiration to his community members and quite likely to have been the light which made Justice Natarajan choose to become a lawyer. It was also a decision which allegedly, I do not know how far it is true, arose out of a mistaken choice by Justice Natarajan in having opted for a wrong combination of subjects for his pre-university because his intention was to become a doctor, but he did not choose natural science, physics, chemistry, and therefore what became a loss to the world of medicine was a gain to the legal fraternity. I conclude once again thanking the family members of Justice Natarajan and the organizer of this evening for giving me the opportunity to share my thoughts and celebrate the centenary of a gentleman who lived respected and died regretted. Jai Hind.
Thank you, sir, for taking us back in a journey of flashbacks and an anecdotal reference to your very first appearance. Your words about Justice Natarajan have kindled thoughts about a great man and his deep sense of friendship. The light and times of Justice Natarajan have reached out and touched the journeys of many personalities and their dreams. In building institutions, individuals also play an indelible part that is remembered and recalled. In that way, the association between Justice Natarajan and Dr. G. Viswanathan, Chancellor, VIT Deemed University, has been a treasure of friendship. May I request Dr. G. Viswanathan to say a few words.
அனைவருக்கும் வணக்கம். Honorable Justice B.V. Nagaratna, Judge of the Supreme Court of India, Honorable Justice Sadasivam, Honorable Justice Krishnakumar, Honorable Justice Ibrahim Kalifulla, Honorable Justice Nagappan, our Advocate General Mr. P.S. Raman, Ramesh Rajan and brothers and the relatives of Justice Natarajan, judges and ex-judges, former judges, senior advocates, students of law, distinguished invitees, members of the press and media, very good evening to you. I am so happy that the family celebrates one of the best human beings who lived among us. He lived for 90 years, and in that 90 years, almost 45, 50 years, I knew him, and we had very good relationship. Of course, we became relatives also. When we started the college, Vellore Engineering College, the previous name of VIT was VEC. The first batch passed out in '88, and he was the first chief guest to celebrate the convocation, give the degrees to the students. I remember he spent a lot of time with us. And of course, I had number of times used to meet him and discuss various things. In fact, he used to mention that he had illustrious seniors like Shankara Mudaliar, the famous lawyer from Salem. Of course, our Justice Jagadisan's father. He was trained by him. And he always remembered people who helped him in his life. A number of points were raised here. I completed law in '63 and enrolled. In fact, Justice Jagadisan was 1 year junior to me in law college. I enrolled in now, this year I complete 60 years, 64 into this year, but I just practiced only for 3 years. Then late leader Aranja Ranna called me and said, contest election. I was elected to parliament. I lost my profession, legal profession. Justice Natarajan had an illustrious career, and I always feel that judiciary is the most important part of a democracy. I happened to be there in Parliament when there was an upheaval in judiciary in 1973, when first time 3 senior judges were superseded. Justice Hegde, Justice Shalat, and Justice Grover were superseded. And Justice A.N. Ray was appointed as Chief Justice of India. There was a hue and cry. There was so much opposition in the country. From entire opposition joined together. Of course, the strong lady was in power. Indira Gandhi was the Prime Minister. I always remember that there was a public meeting condemning this attitude because they were trying to get the concept of committed judiciary. And of course, one was from our own state, part of this, Mohan Kumar Mangalam. The other one was Siddharth Sankar Ray from Calcutta. These were the brain behind this committed judiciary. And I participated in that meeting, which was presided over by Acharya Kripalani. All the top leaders of India, including Jayaprakash Narayan, Atal Bihari Vajpayee, N.A. Palkiwala, and all others participated. And I remember that judiciary has an important role to play in a democracy and particularly in a federal country. Of course, instead of calling a federalism, we were called a union of states due to various reasons by the fathers of the Constitution. That's why we are called quasi-federal. This will be useful to the law students. They must read about this. There are certain points which I wanted to raise today before the honorable judges and former judges from the point of view of the public, litigants, etc. In our country, court cases, once filed, it's not easy to get a judgment. At present, there are 5 crores and 10 lakhs of cases pending in the country. Out of this, 1,80,000 cases are pending for more than 30 years. Of course, 87% of these cases are pending in the district courts, the rest of them in high courts, and of course 83,000 are in the Supreme Court. These pending cases, in 2018, they were 2.9 lakhs, 29 million. Now it has grown to 51 million. According to Niti Aayog, Government of India, they estimate with the present rate of disposal of cases, it would take 324 years to clear the backlog. All of us were talking about rule of law. And there is an international index, ranking of rule of law index by the World Justice Project. And India's ranking is 111 out of 142 countries. That's how we are lagging behind. And this is for the students of law to note that what is that we are going to do. And how can we dispose of the cases on time? We should think about it. Of course, the lawyers are here and the judges are also here. There are some cases which are pending for decades. In fact, there are 14 cases which are about 70 years old. And there are 4 cases which are 72 years old, out of which one is in High Court of Madras and the rest of them are in Calcutta High Court. This is what the report says. And the court by both by executive, judiciary and legislature. And especially judiciary is the one which has to protect the liberty of the individual, particularly the weak and the downtrodden. When we see that the under trial prisoners in this country, 75% of prisoners in India are under trial prisoners. It means that judgment has not been given. They are not punished by judges. It is only the police and the enforcement directorate and all other officers, they have punished them. Now we have 4,34,000 under trial prisoners in the country. And maximum are in 2-3 states like Bihar, UP, Maharashtra, etc. And in Kashmir, 86% of the prisoners are under trial prisoners. Among them, among the under trial prisoners, those who are there in the prison without a trial, more than 5 years is 11,000 people. I want the honorable judges and advocates to think about it. What is that we can do? I always remember Justice Krishnayer's dictum, bail is the rule and jail is an exception. But here it seems to be the other way. Why should we confine them more than 5 years, 11,000 people? And if the judge is later on in the case, he declares that he is not, it cannot be convicted, what happens? How are you going to compensate him? This is the question which I would like to ask. And again, another important question is cost of litigation. You know, this is a poor country. Of course, we are growing, but the benefit of growth is not going to all the people. I don't know how many of you read this, the economic inequality in this country. And I don't know how far judiciary can interfere in this. The top 10% of the people of this country own 80% wealth of the nation. And the bottom 50% of the population, out of 142 crores, they only own 4% of the wealth of the country. These are the people who go to the court and they have to wait for a judgment. And what happens for poor people or the middle class people? Some of them get government assistance, but it's not enough, or it's not easy to get. And once I accompanied my friend to Supreme Court to meet the advocate. Till the time I didn't know the procedure there. To meet the advocate, you have to pay. It's called conference fees. Where you sit and talk to him, you have to pay rent. If it is half an hour or 1 hour, you have to pay rent for the room. And you have to pay to meet your own lawyer. This is the kind of cases going on. Are we not thinking about it? And as far as the fees are concerned, I am happy that yesterday the High Court of Madras has said regarding the politicians' case, only 3 adjournments will be given. Ministers, ex-ministers, MLAs and ex-MLAs. I hope this will be applied to all cases. Or at least the payment for adjournment will be only for 3 adjournments. You know, in Supreme Court, one has to pay about 10 lakhs of rupees or even more. I think High Courts is almost half of the amount. And we go on paying. It may be exaggeration, but there is truth in it. And I pay for my lawyer not for judgment, only for getting adjournments. How many adjournments goes on? Now it is applied to criminal cases also. And this is the important matter I want the judiciary to consider, the executive to consider, because this country cannot afford to spend so much on litigation. It is all right for the top people who can spend any money, but it's not for the poor and the middle class. We have to see that they get justice within a limited time. What is it that we can do? I want you to consider this on behalf of the clients, on behalf of the public. I am making this request. And Justice Natarajan was a man who was concerned about people, poor people. As it was pointed out, he did a lot in education, particularly women's education. He was there for 18 years as the chairman of Natarajan College. And also he was taking interest in various affairs. And I would like to remember him, not only as an advocate, as a judge, but also as an educator. And his service to education is also always remembered. And I would like to thank his family for arranging this. And also I would like to thank our judges, Justice Nagaratna, other judges for participating in this. I had very close connections with this family and also with his father-in-law's family, P.T. Rajan's family. I have met Sir P.T. Rajan. Of course, his son was very close to me, Palanivel Rajan. Now his son is minister now, Palanivel Tyagarajan. So this is a very big family where he got married. And for 90 years, he lived a very good life. And we always remember, he was very sympathetic to people. It was mentioned here, people come to him for various requests, and he was trying to fulfill whatever possible. I always remember his these fond memories I remember, and I would like to thank his family for this wonderful arrangement. Thank you very much.
Thank you, sir, for recollecting and reflecting on your interactions with the late Justice Natarajan. Your address reminded us of the importance of the judiciary in our national life and to solving the problems that confront our society. It has been an evening of respectful nostalgia and in recounting the life and times of a personality who we shall never come across again. For the family, it has been a labor of love, and to all of us, a call for making a centennial miscellany of moments and memories. In this is also included the message of gratitude. May I request Mr. N. Mahesh Rajan to propose the vote of thanks.
Chief guest of this evening, Justice of the Supreme Court of India, Honorable Mrs. Justice Nagaratna, former Chief Justice of India and former Governor of Kerala, Mr. Justice Sadasivam, sitting Judge of Madras High Court, Mr. Justice Krishnakumar, former Judges of the Supreme Court of India, Mr. Justice Ibrahim Kalifulla and Mr. Justice Nagappan, Tamil Nadu Government Attorney General, Mr. Raman, Founder and Chancellor of VIT University, Dr. Viswanathan, other distinguished guests, family and friends, ladies and gentlemen. Please permit me to share a few personal thoughts and provide a son's perspective about our father before I propose a formal vote of thanks. And in the interest of time, I will keep my remarks very brief. As our distinguished speakers have all mentioned, and as you all fully know, our father was a man of very high integrity, blessed with a keen legal mind and a sharp wit, who enjoyed the company of others, as well as fine food and drink, a gracious host, and always a well-groomed and well-dressed person. But without a doubt, one of his most, if not his most distinctive traits was his care and compassion for others, and his willingness to always be of help to others, no matter who they were or what the circumstances entailed. Whether it be college admissions or job placements or playing matchmaker or settling misunderstandings or disputes between family members or families, or even just by showing an interest in other people's lives, everyone knew that they could count on our father for help and guidance. And if nothing else, that at the very least, they would get a sympathetic ear to their situations. So I will just mention 3 very memorable incidents or narratives about our father that have made a lasting impression on me. First, my parents visited me in Perth, Australia, a month or so before the birth of my only child. My father was extremely relaxed without his usual busy social calendar back home and in very high spirits. And my mother was highly involved in helping us prepare the nursery as well as advising us on how to handle our newborn child. Hence, I requested them to extend their stay and welcome/bless their grandchild in person before going back to Chennai. My mother was quite willing to stay longer, but my father refused, saying that he had to go back to Chennai as originally planned because he had to attend the wedding of one of his very close friends, Advocate Mr. Gandhi's child's wedding. I pleaded with my father, saying that nobody would mistake him if he informed them that he could not attend the wedding because he was in Australia awaiting the birth of his grandchild, and that he could bless the newlyweds once he returned to Chennai. But my pleas were to no avail, and sure enough, my parents stuck to their original travel plans and went back to Chennai a few weeks before the birth of my daughter. I'm sure that my parents' presence at the wedding brought much joy to Mr. Gandhi and his family, but this is a very good indication of the extent to which our father placed an equal, if not greater, importance on special events in other people's lives and treated them as if they were happening in his own family's lives. Secondly, the late great industrialist, Mr. Wallahjah Rd, was one of our father's closest friends and who had a soft corner for me, and likewise me for him, as I greatly admired Obal Uncle for his humility and simplicity. Obal Uncle would always ask me to come and spend a half a day or a day with him whenever he visited Southern California, where I was pursuing my doctoral study. And he would proudly introduce me to others as his good friend, Justice Natarajan's son. And Obal Uncle would always mention to me that there were only 2 people from his circle who received all guests with the same grace, dignity, and respect, regardless of their background. One was my maternal grandfather, the late Sir P.T. Rajan, and the other being our father. This was not only a keen observation on Obal Uncle's part, but an important lesson for me on how to treat others, and that has stayed with me forever. Along the same lines, many a time I witnessed our father get up and wash his hands mid-meal, be it breakfast, lunch, or dinner, much to the exasperation of our mother, because some guest had dropped in while he was having his meal. But this is further corroboration of our father's keen desire to treat guests, particularly non-family members, with the utmost dignity and respect, no matter what the circumstances. Thirdly, after our father passed away in Apollo Hospital, I accompanied his body to our house. By the time we reached home, somebody had already arranged for a shamiana and chairs. Somebody else had ordered coffee and tea, water, and other refreshments for the guests. and there were several dozen people already assembled to welcome the body. Throughout that evening and the following morning, hundreds of people came to pay their respects to our father and conveyed their condolences to my mother and brothers. As expected, there were many dignitaries from the legal community and society at large, including past and present high court judges, lawyers, industrialists, social figures, etc., who stopped by our house. But one person in particular stood out to me personally. She was a very elderly lady who was apparently a vegetable vendor near the Sai Baba temple, which is quite close to our house. After placing a garland on her father's body, she told my mother and us that she did not know who our father was and that she had never interacted with him before, but she heard from the people in the street that a very good human being had passed away, and hence she felt compelled to come and pay her respects to him. This memory was seared in my mind and in my heart, and I was deeply touched by this lady's actions and words. That a total stranger would act in this magnanimous manner, and that people on the street genuinely mourned our father's death, made me fully realize that a person's good deeds and greatness will far outlive their time on this earth. This is further evidenced by this very large gathering of well-wishers who have assembled here this evening to venerate our father's birth centenary, a decade after his passing away. Finally, though this event is to commemorate our father's life and legacy, I would be greatly remiss if I did not say a few words about our mother, who was the ultimate exemplar of the old adage that behind every successful man there is a woman. As is the case with all mothers worldwide, our mother was a very caring, loving, and nurturing person. In short, the glue that held the family together, who also encouraged us all to achieve our goals and dreams. She was a very accomplished person in her own right and was well known for her culinary and artistic skills. She was asked to be the chief guest at many a cooking competition and art shows. But one of her greatest joys came from being a devoted wife and being very supportive of her father in all of his professional as well as personal activities. There is no doubt that their marriage was made in heaven. There is a saying in Tamil, Jadike eta mudi, which roughly translates as the right lid for the right container. And this was very true of our parents. They were a perfect pair who were happily married for 61 years. They thoroughly enjoyed inviting people over for a meal, and they were very well known for their warm and gracious hospitality. As a couple, they were in very high demand to preside over weddings and hand the Mangal Sutra or Thali to the bridegroom, because people wanted the same harmony, marital bliss, and prosperity for the newlyweds that my parents experienced and enjoyed. And many a time when I accompanied them to temples, be it here in India or in Australia or in the US, complete strangers would come and take their blessings because of the grace, goodness, and godliness that they radiated. In short, they were the true Shiva and Parvati in human form. In sum, all these and other incidents, memories, buttress their greatness and nobility. My brothers and I are extremely privileged and blessed to be their children. Not only the three of us, but my sisters-in-law and our children try our very best every day, albeit very poorly, to emulate the high morals, decency, dignity, and nobility that our parents led their lives by. And hopefully future generations of our family will continue to honor and live by these values and standards that our parents left us with. So on behalf of my brothers and all of our immediate and extended family members, I want to thank each and every one of you for honoring our father's life and legacy by your gracious presence at this function. I salute my brother Ramesh and my sister-in-law Uma for their meticulous and tireless planning and organizing of this grand event, and my other brother Suresh and my sister-in-law Taila for ably assisting them with all of the logistical arrangements. This is one more seva that they have done for our parents. They were, of course, helped by many others, but I will just mention a few individuals for their tremendous and gracious help in making this function a reality. Former Judge of the Madras High Court, Justice Jagadishan, Chairman and Managing Director of Vivek and Company, Mr. Raman, Senior Advocate of the Madras High Court, Mr. K. Dorasamy, Shivalayam's Mr. Mohan, and our cousin's husband, Mr. Tirumurthy. Thanks also to all the staff members for their assistance during this evening. My sincere apologies to anyone else that I might have overlooked, but please do know that we greatly appreciate your help in making this function a possibility. Though our father was never motivated by fame or fortune, and he never ever sought to be in the limelight, I can confidently say that he would be greatly touched by this wonderful ceremony, which is an apt tribute to his life and legacy. So once again, from the bottom of our hearts, we are extremely grateful to you all for honoring him this evening. Namaste.
That was such a personal touch to a very special evening indeed. And this was an occasion to remember and cherish, made extra special with our honored guests, their lordships and other distinguished invitees. And we are sure that Justice Natarajan has been brought alive not just through this souvenir, but through his acts and deeds that have gladdened many hearts. Before we close the evening's proceedings, we request that those who are desirous of obtaining a copy of the Centenary souvenir to kindly collect your copies outside the auditorium from the kiosk stationed. And there are also digital versions of the same book that will be made available, and the files will be shared. I also believe that a bunch of keys from a person of the audience who came on a cab from Cathedral Garden Road has been missed. And if that person is looking for the bunch of keys, they are with Mr. M. Tirumurthy outside. You can claim and collect it. With that, may I request all of you to rise for the national anthem.